Good evening and welcome to Courts Today by Live Law. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. I am starting with an important judgment delivered by the Supreme Court today which discusses the Prevention of Money Laundering Act. The bench comprising Justice Abhay S. Oak and Justice Pankaj Mittal pronounced the judgment in an appeal against a judgment of the Karnataka High Court. For your understanding, let me tell you, Prevention of Money Laundering Act can be invoked or applied to only those offences which are mentioned in the schedule of the Act, or more precisely to proceeds of crime arising out of such offences. Section 120B of IPC, that is criminal conspiracy, is a scheduled offence under this Act. In the present case, the FIR was registered under various sections of IPC for criminal breach of trust. Criminal breach of trust is not a scheduled offence under PMLA. But in this case, ED applied PMLA by invoking Section 120B of IPC. A complaint was filed by ED in March 2022 against the former Vice-Chancellor of Alliance University under PMLA for money laundering. The special judge took cognizance and proceeded with the case. In response, petitioner approached the Karnataka High Court seeking to quash the proceedings. But the High Court, relying on the judgment in Vijay Madan Lal Chaudhary versus Union of India, emphasized on the phrase used by the Apex Court which said any person and not any accused. So one need not be accused in the principal offence to be subject to proceedings under PMLA. The court further held that even assisting in the process or activity constitutes a part of the crime of money laundering. Against this, the appellant approached the Supreme Court. An important question arose whether Section 120B of IPC can be utilized independently by authorities under PMLA for investigation or if it must be read together with other scheduled offences. In this judgment, the court has clarified that an offence of criminal conspiracy punishable under Section 120B will be deemed a scheduled offence under PMLA only if the alleged conspiracy is directed towards committing an offence specifically included in the schedule of the PMLA. Also, it may be recalled that last week the special bench, which was hearing applications to reconsider the Vijay Madan Lal Chaudhary judgment, had orally remarked that ED cannot invoke Section 120B when the criminal conspiracy is not linked to a scheduled offence. The Supreme Court bench comprising CJI Chandrachud, Justices J.B. Pardewala and Manoj Mishra was today hearing the writ petition filed by the state of Kerala against the Governor Arif Mohammed Khan's inaction on 8 bills passed by the state legislature. Senior advocate and former Attorney General for India, K.K. Venugopal, appearing for the state government, informed the bench that after notice was issued on the writ petition, the governor cleared 1 bill and referred the remaining 7 bills to the president. He highlighted that some of these bills had been pending for 2 years. He also stressed on the need to lay down guidelines on governor's power to refer bills to the president. However, the bench pointed that a prayer for guidelines would be broadening the scope of the present writ petition. In response, the former Attorney General requested to amend the petition accordingly, which was allowed by the court. The bench criticized the conduct of the governor, saying that no reason had been given by him to keep the bills pending, and that the power of governor could not be utilized to pause the lawmaking exercise of the legislature. The bench also noted the assurance given by the Attorney General R. Venkata Ramani that the governor will take necessary actions. In another important update, the Supreme Court today allowed the union government to extend by 6 months the term of Delhi's Chief Secretary Naresh Kumar, who is otherwise due to retire tomorrow. The court held that the central government has the power to appoint the Chief Secretary of the Delhi government and that such power includes the power to extend the term of the superannuating officer. A bench led by Chief Justice of India, D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Mishra was hearing a writ petition filed by the Delhi government against the union unilaterally appointing a Chief Secretary or extending the term without consultation with it. But the bench rejected the plea. To turn down the Delhi government's plea, the bench referred to the recent services law passed by the Parliament, that is Government of NCT of Delhi Amendment Act of 2023, which gives the centre overriding powers over GNCTD services. Although the issue relating to the validity of the Act has been referred to a constitution bench, the operation of the Act has not been stayed. The bench also pointed out 3 subjects that are constitutionally excluded from the powers of the Delhi government, that is public order, police and land, and the Chief Secretary has to deal with these excluded matters as well. To read in detail about this case, you can visit our website at livelaw.in. Today, the Supreme Court for the 8th time adjourned the hearing of former JNU scholar Umar Khalid's bail application in the Delhi riots' larger conspiracy case. As Senior Advocate Kapil Sibal and Additional Solicitor General S.V. Raju were unavailable, both the petitioner and the Delhi police requested an adjournment. Khalid has been behind bars for over 3 years now, awaiting his trial under UAPA for his alleged involvement in the larger conspiracy surrounding communal violence that broke out in the national capital in 2020. The matter was today postponed to 10th January next year, where the bench will also consider a set of writ petitions which have been filed challenging the constitutionality of certain provisions of UAPA along with Khalid's bail petition. Also, Senior Advocate Arvind Dattar, appearing for the Foundation of Media Professionals, today requested that the petitions challenging UAPA provisions should be referred to a 3-judge bench. To support his request, he pointed out that the plea to reconsider constitutionality of provisions of PMLA is before a 3-judge bench. Since the bail provision in PMLA, which is Section 45, is identically worded as Section 43D of UAPA, the matter should be heard by a 3-judge bench. Advocate Prashant Bhushan, who was appearing in a petition challenging UAPA FIR registered by the Tripura police over a report on riots, also raised a similar request. However, Justice Bela Trivedi refused to detag the writ petitions or refer the matters to another bench. In another update, the Directorate of Vigilance and Anti-Corruption, that is DVAC of Tamil Nadu, has objected to listing of a matter before a bench led by Justice Bela M. Trivedi, stating that it was earlier listed before a bench headed by Justice Aniruddha Bose. The case relates to the alleged state highway tender scam against former Tamil Nadu Chief Minister E.K. Palaniswamy. So, an appeal has been filed by DVAC against a Madras High Court order which ruled that there was no reason for conducting another preliminary inquiry against Palaniswamy, as the earlier report did not suffer from any apparent illegality or unreasonableness. The High Court had said that the fresh inquiry was ordered against him only due to change of government in the state. In a letter written yesterday, the advocate on record D. Kumaran had written to the Supreme Court Registrar requesting the matter to be listed before the bench led by Justice Bose. He pointed out that the matter had come up in September and October before the bench presided by Justice Bose, and the matter was listed for hearing today. Referring to the Handbook on Practice and Procedure and Office Procedure on Judicial Side based on the Supreme Court rules, the letter states that once a matter has been allocated to a bench, the case is required to be listed only before that bench and no other. Today, the matter was actually placed before a bench comprising Justice Bela M. Trivedi and Justice Satish Chandra Sharma. Senior Advocate Dushyant Dave, appearing for DVAC, protested the change in the bench. The court then directed DVAC to move an application before the registrar for listing the matter before Justice Aniruddha Bose's bench, subject to orders from the Chief Justice. The Madhya Pradesh High Court has dropped 2,624 contempt cases and 1,938 show cause notices issued against advocates in suo motu contempt proceedings, which were initiated against individual lawyers in March this year. This was for their non-appearance in courts to protest against the 25 debt scheme. The scheme was rolled out for swift disposal of 25 pending cases every quarter in all districts in the state. A division bench of Chief Justice Ravi Malimath and Justice Vishal Mishra found that there was no deliberate disobedience on the part of the individual lawyers who actually abided by the direction issued by State Bar Council instead of court order that gave directions to the contrary. The court opined that acts such as that of lawyers abstaining from appearing in courts as a form of protest is fatal. The bar and the bench are partners in the dispensation of justice. Therefore, any act of protest by one institution against the other will be detrimental. The court also took note of the affidavits by both association presidents who tendered an unconditional apology and gave a detailed explanation of the dilemma that occurred to the association members. They submitted that although they knew about the significance of obeying the court orders, they were in state of confusion, also being beneficiaries of certain welfare schemes run by the State Bar Council. This is after the Supreme Court in October had directed the Madhya Pradesh High Court to reconsider contempt notices issued against advocates who were not Bar Council office bearers for not appearing in courts on the strike day. Ashneer Grover, the former managing director of Bharat Pay, has tendered an apology before the Delhi High Court for posting allegedly defamatory posts against the fintech company on social media and also gave an undertaking not to post similar posts in the future. Justice Rekha Palli was dealing with an application moved by Bharat Pay in its defamation suit against Grover and various others seeking to restrain him from making any defamatory statements against it on any platform. The court was appalled to note the persistent violation of judicial orders by Grover. While imposing Rs 2 lakhs costs on him, Justice Palli directed him to pay the amount within 1 week to the Delhi High Court Bar Clerks Association. The court also directed the association to utilize the amount for welfare of families of those clerks who lost their lives during the COVID pandemic. And lastly, the Kerala High Court today ordered that no coercive action shall be taken against Union Minister Rajiv Chandrasekhar for allegedly making provocative remarks and causing religious disharmony in the state after the Kalamasheri bomb blasts. 2 separate pleas were moved by the minister for quashing 2 FIRs registered against him, where he was made the sole accused on the grounds alleging commission of offences such as giving provocation with intent to cause riot and promoting enmity between different groups on grounds of religion. The allegation against him was that he posted provocative remarks through his social media page following the recent bomb blasts. Senior advocate Mahesh Jethmalani appeared for the minister and argued that he had not spoken any words or statements to promote hatred or religious disharmony, nor had he committed any illegal acts to cause rioting. That the registration of FIR against him was nothing but malicious prosecution and he was unfairly targeted with ulterior intentions. Justice C.S. Dias today issued an interim order directing that no coercive steps shall be taken against the minister till 14th December. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.